Hello and welcome. I spent a lot of time thinking of some clever intro for this video, something that piques your interest and that also seamlessly transitions to the topic at hand, which in this video is exploring how our right to a day in court is being blocked when the government is the one that commits the harm. In other words, getting to the bottom of who stole our constitutional right to sue the government. But why would someone like me, someone who has served their country both in and out of uniform for nearly 20 years, be talking about suing the government? I mean, I've controlled nuclear weapons, jumped out of airplanes, maybe not gracefully, read thousands of letters addressed to the president from everyday Americans, and was sent into combat zones. As I learned, it doesn't matter what you've done or who you are. No one is immune from the wrongdoing of others. And in my case, I experienced wrongdoing from the very government I trusted. From my government who had a duty to fulfill its commitment to me and others like me. Although the true nature of what was happening to me was concealed, I eventually discovered that the persistent underpayments, deductions, and even outright denials of pay and benefits that kept happening throughout my career were not simple errors, but rather intentional violations of the law and my rights. And most crucially, that these violations aren't only happening to me, but potentially thousands of other individuals who serve our country in the National Guard and the reserves. For you see, a large portion of America's military is composed of men and women who serve part-time. Most spend 1 week in a month and 2 weeks in the summer training to stay ready should their country need them. And due to the total force concept that has been the bedrock of our national defense policy since the end of the military draft, the need from our country is constant, with hundreds of thousands of reservists and National Guardsmen being placed on active duty every year. It's a tough life for America's citizen soldiers, since they have to juggle the disruptions to their family lives and their civilian careers every month, with weekend drills, summer training, and orders lasting weeks, months, or even years at a time. And then, when they come back, so many face discrimination or retaliation for their service from their civilian employers or even from their civilian colleagues. And through my personal experience, I discovered that the Department of Defense often makes the situation even harder. That paradoxically, the Department of Defense is a perpetrator in mistreatment of the men and women who serve part-time, despite multiple laws forbidding discrimination of uniformed service, as well as mandating the equal treatment of National Guard and Reserve service members with their regular service counterparts. The Department of Defense appears to be systematically violating the law. To provide one example of what I've faced, and I'm sure others have faced as well, when I went on active duty, I was often denied the same pay and benefits that regular forces receive. And when I've complained, it often resulted in even more pay discrepancies, to put it mildly. And because my full-time civilian position was also in the Department of Defense, I experienced double the retaliation because the pay discrepancies impacted my civilian pay and benefits as well. In fact, I have had many tens of thousands of dollars taken from me or denied me that I rightfully earned. I worked in good faith and believed the system would fix itself when confronted with such wrongdoing that it was committing. Over the years, I worked through every entity you could imagine. I went to my supervisor, the Inspector General's office, the Office of Special Counsel, the Department of Labor, and finally, the Merit Systems Protection Board. But with each step I took to make things better, inexplicably, my treatment only got worse. Although it's obvious now, I had such faith in the system that I couldn't believe that what I was experiencing was retaliation for doing the right thing, which was reporting wrongdoing and expecting it to be corrected. After I started providing evidence to the Office of Special Counsel, an entity whose mission it is to protect federal employees from the very behavior I was experiencing, the Department of Defense escalated and cut off pay and benefits. I was forced to turn to the Merit Systems Protection Board. And it is my experience with that organization that made me start realizing that the supposed independent agencies I sought to help me might not be so independent after all. By their very own rules, the MSPB is supposed to process cases within 120 days. Yet, after the judge acknowledged receipt of my case, I have not heard from him since. I've called and filed motions, but I'm ignored. All the while, the Department of Defense continues to deny me pay and benefits. All the while, my family and I are using our last bit of savings just to survive as we fight for justice. As the time passed, I started exploring next steps. And what came to my mind, as I'm sure would come to your mind in a situation like mine, was going to court. But after months of research, I discovered surprising and troubling things when it comes to wrongdoing by the government and one's ability to sue to hold that government accountable for that wrongdoing. And I'm sure you'll be surprised too. Very surprised. I basically had to learn the law from the ground up. What I didn't have in legal training, I made up for in methodical research and a passion for learning. I've always enjoyed reading and learning. In my spare time over the years, I built a website for organizing and sharing notes from some of the hundreds of books that I've read. A website I call Note Climber. In the face of my current situation, I decided to take the advice echoed by Teddy Roosevelt many years ago. Do what you can with what you got where you are. So I'm putting that advice to work and doing what I can with what I've got in order to get me and hopefully others somewhere better. So join me as I share with you the knowledge and experience that has come at great cost to me and my family, and that I hope will help you should you ever be in a time of need like me. Because what I'm about to share impacts the rights of every single American. Now, there is one other thing I want to add about this video and future ones. In my life, I've always used humor to help me through tough times, and this situation is no different. I'll use some lighthearted elements to help me convey certain points. Although I may use silly voiceovers or entertaining special effects, it doesn't make the issue any less serious or important. I opted to create an educational TV show format since I have a long-term vision of exploring many more topics and want to make the material not only deeply informative, but also lightly entertaining. So with that in mind, let's go ahead and go to some dazzling intro effects. Now, I'm not a lawyer, so I can't give legal advice, but I can share my personal experiences and the knowledge that I find useful regarding one's right to sue the government. And even though I may not hold a law degree, I do have years of formal education and the political and policy foundations and events that created the basis of our legal system. But beyond my political science major or my master's degree in public policy, I simply love to read about government and history and politics for fun. So I've incorporated my formal and informal knowledge to be able to derive the knowledge that I'm presenting here today. Paradoxically, I think it was my lack of formal legal training, along with my strong background in the fundamental aspects of American politics and history, that helped me discover or spot certain things that are otherwise widely accepted, often without question. And unfortunately, the secret ingredient to all this was crime. Not mine, of course. It took fundamental violations of my rights and obvious violations of the law by others to get me started on this journey. The knowledge of how our system is supposed to work, contrasted with my personal experience of how it isn't working, forced me to examine why. And the answers I found on that journey make up this and future episodes. So with us having covered a bit of my personal plight, it's now time to shift gears to the rest of the show. I will cover one of the many surprising things I've learned in my research, which is our right to sue the government, is being blocked. By the way, there's an introductory video detailing more about my situation and the violations of my rights available on my YouTube channel. Let's now turn to some ground rules of the show. I've always been a big fan of Bob Ross. I would watch his Joy of Painting episodes on PBS when I was homesick from school in the late 80s and early 90s. In the same way he would run the colors across the screen, I'll be running all the nonfiction sources we'll be using in this video at the bottom of your screen. And throughout this episode, I'll be pointing out specific notes from those works to help guide us in our journey of discovery. All the notes I cover in this episode, and many more, can be found on noteclimber.com, which allows you to organize notes from nonfiction works by source type, such as book or newspaper, and even by subject, if you're so inclined. For this episode, I created a note set titled Note Climber, Season 1, Episode 1, where all the notes discussed in this episode are located on one webpage for easy reference. Now that we've talked about structure, let's get to the content, shall we? If you're anything like me, there are particular scenes that flood your mind when you think about justice and being able to get wrongs righted. You may think of old television shows like Perry Mason, with that fictional lawyer's dogged determination to collect all, and I mean all, the facts of the case. Or movies such as 12 Angry Men, following the heated debates of jury members taking their roles in the judicial process to heart and determining what the truth is based on the facts of the case. Regardless of the specific fictional work that may come to mind, our culture has reinforced the idea that when you are harmed by someone, there is an institution in place to give you and anyone else a fair and independent hearing to determine conclusively the wrongs that were committed, and most importantly, to provide the remedy to correct those wrongs so you can get back to your life with as little negative impact as possible. And there is a reason why we have these perceptions in mind, and that pop culture reinforces these notions. It's not just a matter of justice, but a matter of law. And in our country, it's guaranteed by not just any law, but the most supreme law, the Constitution of the United States of America. But before we start talking about the Constitution, we probably should first do a quick review of what led to the Constitution in the first place. To save time, I'll give you the Reader's Digest version of the Reader's Digest version of that history, just as a quick reminder. As you may remember from history class from elementary school, or deduce from the fact that we speak English, we used to be a colony of Great Britain. But we got tired of King George telling us what to do, taking away our jury trials and taxing us without representation. We ended up sending a breakup letter, but King George didn't take that split very well, and so there was war. But America was not going back and found someone new, someone with an exotic accent and a really good wine collection. After a few years of fighting, we finally got the king to agree to the breakup in writing, and he did so in the home of our new significant other. Now, afterwards, the first attempt at a national government didn't work out too well for the newly independent United States of America. The Articles of Confederation were too loose. Under that compact, there was no president, Congress didn't have the power to raise money, and states could choose not to follow the laws Congress passed if they didn't feel like it. It was a mess, and many of the founders quickly realized that something better was needed. Congress set up a convention, and I know what you're thinking. You're thinking, oh, he's talking about the Constitutional Convention. Well, not really. Congress didn't set up a Constitutional Convention, but actually one to only amend the Articles of Confederation, not replace it. But the members of the convention came to the consensus that the Articles had to be completely replaced. They didn't ask for permission, but figured they would just ask for forgiveness afterwards. Regardless, it all worked out, and the Constitution of the United States was ratified by all 13 original states. So let's start digging in to find out what exactly the Constitution says about our right to sue the government. Under Article 3 of the Constitution, which is the article that deals with the judiciary, that separate branch of government that is composed of the Supreme Court and inferior courts, such as trial courts, it states the following.
The judicial power shall extend to all cases, in law and equity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority.
I forgot to warn you, I'll be using authoritative voices, not mine, but authoritative, to add gravitas to some of the texts we'll be covering in this episode. So, based on that portion of the Constitution alone, it seems fairly clear. All cases in law and equity arising under the Constitution and the laws of the United States, that indicates that if it's a case about a constitutional issue or a violation of federal law, an Article 3 court doesn't just have the authority to review it, but those cases shall extend to the court's power. By the way, when Congress uses the word shall, it's kind of a big deal. Further down in Article 3, Section 2, it states the judicial power also covers
controversies to which the United States shall be a party.
And you could be a party in a case as either the plaintiff, which is the one who is bringing the suit and alleging the wrongdoing against the other, or the defendant, who is having the allegations waged against them. But either way, the Constitution says a party. Not whether it has to be a plaintiff or a defendant, just a party. Now it's time to turn to the Bill of Rights. Usually when someone tells me to look at a bill, I want to run the other way. But the Bill of Rights is a bill you want to run towards, since it's a bill that the government is responsible for paying you. But instead of cash, it's a payment in rights. The Bill of Rights are the first 10 amendments to the Constitution that lay out specific rights that are held by individual citizens, and even some listed for the states. They actually came a few years after the Constitution was first ratified. But that doesn't mean they're any less important than the original version of that document. In fact, a number of the states only agreed to ratify the Constitution with a promise that a Bill of Rights would be added later. So the Constitution itself was ratified in 1788, and the Bill of Rights came in 1791. There are 2 amendments within the Bill of Rights that are particularly pertinent to our discussion. And those amendments are, drumroll please,
in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved.
The 6th Amendment established the right to trial by jury for criminal offenses. And because we are reading the amendments in sequence, they are numbered after all, the 7th Amendment preserved that right for suits at common law. In other words, civil lawsuits. The use of the word preserved and the term common law will be very important in my later episode on jury trials and that coverage of how jury trials are actually an endangered species. But that's for later. For our purposes now and for this episode, we just need to establish that jury trials are set as a right and that there are no exceptions listed that would preclude that right in a case against the government. And by simply reading the text, we met that objective. I guess that solves it. We're done. We use the plain text of the Constitution to establish that we have a right to sue the government. Mission accomplished. Wait, what? Oh no. I heard rumors, but I didn't think it was real.
You'd better believe it. I am the great John Marshall, and I proclaim what the law is.
It's not a rumor. That's the voice of John Marshall, the man who served in George Washington's army, was later elected a Congress member from Virginia, appointed Secretary of State in the John Adams administration, and most famously, and with great consequence, the longest-serving Chief Justice of the Supreme Court of the United States of America. But the question now is, why is he here?
I have become aware that you read the Constitution without the supervision of a Supreme Court justice. I am here to remedy the situation and read it for you properly.
But Justice Marshall, I appreciate your help, but the Constitution is pretty clear on what I'm focused on, the ability of an individual to sue the government. Besides, it's my understanding that the court only brings judicial interpretation and precedent into the equation when the text of the law at issue or the Constitution isn't clear. Otherwise, the Constitution is supposed to speak for itself.
We are breaking up, but I believe I heard you say, Justice Marshall, help. And so I shall. I summon another Supreme Court justice with a name that is 2/3 as great and distinguished as mine, Justice John Marshall Harlan.
Oh, great. Now I have to deal with two of them. John Marshall Harlan, who served in the Supreme Court as Associate Justice, not Chief, but Associate, from 1877 to 1911, is not related to the first John Marshall, but was nonetheless named after that earlier John Marshall because his father admired him so. Now, John Marshall Harlan was known as the Great Dissenter, mainly because he was on the other side of the majority for a lot of Supreme Court cases. But not everyone, because there was one Supreme Court case in particular that we're going to go over where he was actually on the majority side, with great consequence.
I understand that there is confusion on your part on what the Constitution means, and you need my help to read it. Obviously, your unjudicial eyes are not suited for the task.
But I was reading exactly what the Constitution says, and it plainly supports that a citizen has the right to sue the government.
I will correct you with precedent. Through the case of Hans versus Louisiana, in the year of our Lord, 1890, I concur with the court in holding that a suit directly against a state by one of its own citizens is not one to which the judicial power of the United States extends, unless the state itself consents to be sued. The court has spoken.
But what
I
about...
proclaimed already that the court has spoken.
Well, that was weird. But let's break down what that disembodied judicial voice from beyond the grave was talking about. Many constitutional scholars point to the Hans case as the full establishment of the concept of sovereign immunity in America. Well, at least regarding suing a state. We'll get to the reasoning regarding the United States in a few minutes. The details of the Hans case itself are not vital to our discussion, other than to point out that it involved a citizen of Louisiana suing the state of Louisiana in federal court over a bond dispute. The opinion of the court, as concurred by John Marshall Harlan, was that an individual is not able to sue their state due to the 11th Amendment to the Constitution.
The 11th Amendment.
Well, that was weird. I'm now going to allow the deep-throated authoritative voice to read off what the 11th Amendment actually states.
The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state.
So it looks like John Marshall Harlan was bringing up an amendment that does create a restriction for suing the government. Fair enough. But it's awfully specific, and it doesn't lay down a broad restriction, but rather only a very focused one against non-citizens from suing a state. So if there are no other restrictions based on the Constitution beyond the 11th Amendment, which doesn't bar citizens from suing their own government, whether that be their state or the United States, then why is the court saying such restrictions exist? Well, there is another reference in the Hans case, and it just so happens to be a previous Supreme Court case. And that previous Supreme Court case just so happens to have been the catalyst for the 11th Amendment. So maybe we'll find our answers in that earlier court case. And that earlier court case is, drumroll please, the 1793 Supreme Court case of Chisholm versus Georgia. Again, I'm going to press the skip the unnecessary legal case details button. That's a real button. And focus on just the key facts. The case revolved around a citizen of South Carolina suing for money owed by Georgia for supplies that were furnished to Continental troops in Savannah during the Revolutionary War. Georgia claimed that they couldn't be sued in federal court since they were a state. When the suit reached the Supreme Court, Georgia refused to even show up for the proceedings since they basically used the "no, you can't" legal argument. Is that a real thing? Regardless, the Supreme Court still looked at the case and looked at the Constitution and the same parts that we looked at. Well, minus the 11th Amendment, of course, since that came after this case. Regardless, after their review, the court came to a clear and decisive opinion that citizens can sue another state. In fact, Although it wasn't a question in the case, Justice William Cushing, one of the 4 justices writing a concurring opinion supporting that a citizen had a right to sue another state, highlighted what the Constitution's words mean in a larger sense.
One other objection has been suggested, that if a state may be sued by a citizen of another state, then the United States may be sued by a citizen of any of the states, or in other words, by any of their citizens. If this be a necessary consequence, it must be so.
If this be a necessary consequence, it must be so. Those are very powerful words. Words of one of the first justices of the Supreme Court, affirming that a citizen can sue a state and even the United States. 3 other justices, including Chief Justice John Jay, also ruled that the Constitution allows suits against a state. They base their decisions on the words of the Constitution. The lone dissenter, Justice James Iredell, however, based his position not on the Constitution, but on, wait for it, a foreign law. And incredibly, it's his dissent based on that foreign law that is cited even in modern times to justify sovereign immunity for states. And even some even point to that to justify sovereign immunity for the United States. We'll talk more about that foreign law later. Right now, we need to examine the reactions of the majority opinion of the Chisholm case, since that's what counted, at least at the time. The reaction was strong and swift. Congress, within a short time, well, short for Congress since it still took a few years, passed the 11th Amendment and got it ratified. You remember the one that forbade non-citizens from suing a state? Did Congress, when they initiated this action, think government should be fully immune to do whatever it wants? No. Their reasoning actually had nothing to do with immunity from accountability from citizens, but everything to do about money. And not just any money, but money the states owed citizens and merchants. Because the case was a dispute about bills that Georgia racked up during the Revolutionary War and didn't pay. But this case was just about one merchant. There were many merchants that Georgia owed money to. And it wasn't just Georgia. Every state had claims against it for debts owed from the war. And because it was still only just a few years after the formal hostilities had ended with Great Britain, those states had little funds to function, much less pay globs of money for outstanding bills. So going back to that Hans versus Louisiana case, well, I guess going forward since we started with that one and then went backwards to Chisholm, regardless, we now have notes proving that the purported reasons for that decision, which was that a citizen couldn't sue his own state because of the 11th Amendment, is a bunch of hooey, technical term, when you actually read the 11th Amendment. And the Chisholm case might have been ruled differently if the 11th Amendment was already in place, but that still wouldn't have mattered because that was so specific about non-citizens suing a state. Doesn't apply for citizens suing their own state. So in light of all this, it makes no sense that the courts say the Constitution means something it obviously doesn't say. But going back to that lone dissenter in the Chisholm case, the justice who was citing a foreign law I haven't identified yet, a foreign law that I'm sure you're on the edge of your seat waiting for me to say, don't worry, I'm about to get to it. It definitely makes even less sense that the court cite Justice Iredell today as some type of hero and place that foreign law along with his dissent above the Constitution. So what foreign law is it? Another drum roll, please. English common law. And beyond it being cited in a case about suing a state, it's actually used more in the support of the court's ruling that the United States government is immune to lawsuits. Well, unless Congress explicitly allows it. As we're about to learn, the story of sovereign immunity covering the federal government is even more tenuous than the one that conjured up the notion for individual states. But before we untangle that mess, we first need to understand what English common law is. To put it simply, English common law is judge-made law. In England, by judge-made law, I'm talking about law based on judicial decisions and precedents. In other words, law built around previous court cases. This is very different from civil law, which is based on codes and statutes. And for the purposes of how the U.S. courts have framed English common law as they claim it applies in America, they point to specifically what existed at the time of the ratification of the Constitution or the Bill of Rights, depending on the topic at issue. So basically, the courts are saying Our law is structured around what existed in England at the time of either one of those documents being ratified. I've got some choice words, but I'm going to restrain myself and put things more artfully than my initial impulses would compel me to do. So, with all due respect, that's just stupid. The last time I checked, we won the revolution. We're America. I mean, we're cool with Great Britain, but that doesn't mean we're putting up portraits of the king in our living rooms. In fact, we broke all bonds with Great Britain once we sent King George the Declaration of Independence. Practically speaking, English common law became null and void in America the moment we declared independence in 1776. Everything that existed afterwards was distinctly American. But this begs the question, how did this idea of using this foreign law, which we categorically denounced, become the basis the courts used for denying Americans their right to seek redress from their national government in their courts? Well, the first official action, or I guess pronouncement or statement, to assert that sovereign immunity existed for the national government in America actually comes from the 1821 Supreme Court case of Cohens versus Virginia. And it was a statement not regarding the issue at hand of that case, which was whether the federal courts could review a state decision about federal law, but rather a statement by none other than Chief Justice John Marshall, the original John Marshall, that is, about something that didn't pertain to the case. Before I bring up the particular statement in that opinion, I want to highlight that what he stated is something that is actually supposed to have no binding effect, since it was outside the scope of the issue at hand in that case. He brought the following statement up despite it not being relevant at all. Basically, it's the textual equivalent of photobombing someone's family picture.
The universally received opinion is that no suit can be commenced or prosecuted against the United States.
By the way, those types of non-relevant statements are known as dicta in the legal world. So, a little knowledge for you. One important thing to note about what John Marshall just stated is that he doesn't cite a source for his position. Earlier in his opinion, he hints at his source by explaining that the situation pertaining to the case exists in England as it does in America, seeming to allude to English common law. But that's as far as he goes. And there is a reason for his being coy when it comes to sourcing such a pronouncement. And it's simply because there is no such thing as sovereign immunity in America. Later court cases and legal minds tried to justify sovereign immunity in the United States through the only way they could. And that was by stating that we simply kept the concept of immunity of the government from English common law. As we've established, that's wrong. And you don't have to go far to see why it's wrong. And I'm not even talking about the Constitution, even though that should be enough. The individual opinions of the four justices that were part of the majority in the Chisholm versus Georgia case lays it out clearly in every way imaginable how one has a right to sue the government. In those opinions, you find the historical basis for the right to sue the government, even in England. And in those opinions, you find the logical argument for suing the government. Also in those opinions, you find the textual argument for suing the government, going directly from the Constitution itself. But beyond sovereign immunity being a fiction that is repugnant to the Constitution, it's also something that creates lasting harm. It allows the government to commit wrongdoing and get away with it. It enables the government to bind victims up in supposedly independent forums that, instead of bringing justice, only waste time and resources. And as my case illustrates, resources that the victims have very little of. Sure, it may seem like the system is working, that people are getting their day in court against the government, with headlines announcing a federal agency being ordered to reinstate laid-off employees, for instance. There is a perception that things are going right. But the dirty truth is, the vast majority of headlines highlighting those types of actions are actually dealing with preliminary injunctions or temporary restraining orders. Those aren't final orders, but basically holding actions until the judge can review a case fully. The most important and lasting actions that happen, the ones that actually matter, are the ones that happen later, and those aren't usually written about. And those final actions, for most cases against the government, involves the case being dismissed because of sovereign immunity. And the cases that do gain even some success are limited, since the courts, as they are ruling today, say Congress has to explicitly waive sovereign immunity. And even then, the damages are limited. and the individual normally doesn't get a jury trial. I could go on and trace the later major court cases that added to the facade of sovereign immunity as it is invoked today, and then gripe about them as well. But quite simply, there's no need for it. We went to the source, the original source, the Constitution, and then looked to the original Supreme Court for their view of the matter. And then we traced how the 11th Amendment was misinterpreted to restrict citizens from suing their own state, and how a foreign law, English common law, is invoked to shield the federal government from accountability. So, what does this mean, and why should you care? To answer that, I want you to come with me on a thought experiment. Imagine if, due to your race or background, you and your family were forced out of your home into an internment camp by the government. The government eventually releases you and your family, but the damage to your life is lasting. You lost your home since you didn't bring in any income to pay for the mortgage while you were interned. You lost years of your life that can't be replaced. Then afterwards, you turn to the courts, but then they dismiss your case, citing sovereign immunity. The scenario may seem far-fetched, even fantastical, but it happened, and it happened to thousands of American citizens of Japanese descent during World War II. While most might not be placed in an internment camp, individuals every day are still having their rights stripped from them. And to add insult to injury, when they go to the courts, they turn them away. It's not unpatriotic to bring up these issues and to pursue justice. In fact, it's the highest form of patriotism to expect your government to adhere to the principles of that most American of documents, the Constitution. You have a voice. Don't be afraid to use it. I'm using mine, and I'm letting my Congress member and senators know where I stand and demand to know where they stand. And I encourage you to do the same. And if I may so humbly ask, I ask you to share this video and also send me a message. I want to create a network of like-minded individuals that are pursuing knowledge and pursuing change. Finally, before I go, I would like to ask for your donations. Frankly, I need all the help I can get since I've had my salary and benefits denied and taken from me for months. The supposed independent agency that is meant to protect my rights and others as federal employees has only added to my harm by doing nothing. Is what's being done to me part of a playbook that agencies use to silence those that bring clear evidence of wrongdoing within the government that the government doesn't want corrected? Does the government run out the clock on people like me? Run out the clock until the person exhausts all of their funds to the point they can't afford to fight anymore? If you can, I'm asking you to donate, and to do so now. It would mean the world to me, and would also allow me to keep fighting, and also continue turning my research and reading and experiences into sources of knowledge that I very much intend to share. There are two options for donating shown below on your screen. One is through a GoFundMe campaign set up by a family member, and the other, for those technologically inclined, through digital currency donations. Finally, I want to thank you. I want to thank you for your time. I want to thank you for your attention. And I want to thank you for any help you're able to provide, even if it's just sharing this video. I appreciate it. And I hope you join me for future episodes, because there's a lot more that I plan on talking about. A lot more that I think needs to be addressed. Thank you.